All right, everyone, we are live now. We're going to start voting. We are on vote list number 17, and we're just going to go in order. A couple of the bills we have to hold just because we're still workshopping them, but let's go Senate Bill 20, which is Senator Carter. So, Josh, you're up.
This bill eliminates imprisonment as a possible penalty for a person convicted of displaying a canceled, revoked, or suspended license. The bill also reduces the points assessed from 12 to 3 for these violations. Exceptions are made when the underlying suspension or revocation is due to violations related to certain alcohol or drug-related offenses. You have an amendment in your packet that is number 893428/1. So this amendment conforms the bill to the House cross-file, which has already passed out of the House, by eliminating those exceptions for certain alcohol or drug-related offenses.
Move favorable. So just briefly, the House amendment actually originated from us. We were the ones who came up with the idea to take out the alcohol-related offenses. It's sort of a no-brainer bill, and it's kind of just a last tier of our effort to kind of decarcerate for these driving offenses, where there's rarely, if ever, even a prosecution or a conviction. This is just display of a license. And we've made an exception for if it's suspended for alcohol related, so that shouldn't be a thing. It shouldn't be controversial. I'd move favorable on the bill.
All right, excellent. Let's go ahead and adopt the amendments first. Is everyone okay with doing that? Yes. All right, excellent. So now the bill is before you as amended. Any further discussion? All right, we have a motion for a favorable with amendments. It has been seconded. Is everyone okay? All right, the bill passes as amended with amendment unanimously. And you also have a stellar cross-file, Senator Carter.
So we're only getting... That's okay. That's okay if we are. I'm good.
I'm just giving a hat tip to the cross-file.
I think one of
We're
his
doing it for you.
His delegate.
Yes.
Well, that makes me wonder if I should have voted for this.
All right. All right, move on to, so Senator Heddleman, so Senate Bill 154, we are still workshopping that and just have conversations. I'm going to have Heather just provide a brief overview and pass out some amendments that are an outline of some of the amendments that are forthcoming that might be proposed, but then also flag for the committee that we're still working with the Budget and Tax Committee to come up with some sort of a scheme for the fees, which will be accompanying this, which is Senate Bill 530. So we're going to hold Senate Bill 530 and Senate Bill 154 because we're still working out the details. So hopefully we'll have it back before you tomorrow or Friday. But I'll just turn it over to council for a brief explanation of the amendments that are pending.
Yeah, so on your chair when you came in for voting, there was a double-sided document titled Overview of Voting Packet Amendments for Senate Bill 154. So this is just a general overview, and it does not include Senator Heddleman's proposed amendments. I broke down the amendments generally about what they go over. It includes amendments to the fund, amendments to Section 8-904 in the bill, which is when the coordinator shall provide access to legal representation. Amendments for when, as to timing, access to legal representation should be appointed. A sunset provision, amendments to the task force, and then amendments to add a right of counsel in certain civil proceedings. So again, this is just a general overview. If you want to actually look more into the amendments, I recommend looking at the actual amendments in the reprint itself, which was emailed out to you earlier today in your voting packet. But that's just to help since there are a lot of them. And then not included in the overview of the voting packet is Senator Heddleman's amendment, which was in the actual voting packet. That was a more comprehensive amendment that went through the entire bill, not just the specified groupings here. The main things in that amendment is, so the bill altered the definitions The bill altered the definitions of certain defined terms, in particular covered individuals, to specify that the adjusted income was adjusted for household size. It also altered the definition of legal representation, and then added the definition of the Maryland Legal Services Corporation, because the bill strikes the Attorney General from the bill and replaces it with the Maryland Legal Services Corporation. So so under Senator Hellman's proposed amendment, Maryland Legal Services Commission, or MSLC, would be in charge of administering the program under the bill. Do not. Yeah, so I don't know if they've passed theirs yet. Additionally, the amendments also strike the task force in its entirety. It strikes a requirement that a designated organization shall provide covered individuals with legal representation unless certain circumstances are met. So that's struck on page 5 of the bill.
We're going to get into this during the hearing, during the work group, but just, does that amendment have MLSE, like, administering the program or distributing
Yes.
the funds?
Both.
Both, okay.
The change is made consistent throughout the bill, so they are in charge of administrating the program in its entirety, and then also, as far as the funding goes, they are the corporation in charge of, MLSC shall administer the fund. The fund also is slightly altered under the proposed amendment. The interest earnings from the fund are put into the fund. Generally, that's what it does.
So the work group will address a number of the amendments and the recommendation from Budget and Tax. So we'll work with those and we'll come back. So those two bills are held. So Senate Bill 530 and 154. And Senator Heddleman, anything else to add? I mean,
I would love to, some of the amendments that have been proposed are moot now because of if we adopt this revised amendment that Heather just went through.
so would you like to adopt that amendment and
I
then we can
would.
work?
I think it would be helpful to everybody.
Okay, so then next time we visit this, we'll just work off of the amended
That would be
version.
great. if
So
people
we're
are
talking
amenable.
about Senator Heddleman's amendment.
Oh, and then, so if Senator Heddleman's proposed amendment is adopted, if you look at the cheat sheet that I passed out, the only amendment that would be no longer pertinent would be the amendments under the amendment to the task force about the membership, because Senator Heddleman's amendment would strike the task force in its entirety. All the other amendments, technical changes to incorporate them, but they could still apply.
Hey, that's 1 out of 11, so that's good. All right.
So what number is Senator Hill? That's the 398870, is that the one we're looking at?
Yes.
Review it.
I got a note on this amendment, page 4, the striking of the end and going to the or there on lines, I think it's 21 and 23. What is this doing on this amendment?
Yeah, so this is an amendment that I discussed back and forth with some advocates. So as it's interpreted here, it's more of they described it as a point of clarification. So if you want to read the way it currently reads is, under the program, MLSC shall provide a covered individual with access to legal representation by a designated organization for a judicial or administrative proceeding, 1, to evict or terminate the tenancy or housing subsidiary of a covered individual, and so it's a separate action, and for a judicial administrative proceeding for a violation of any of the following. The concern that was raised, why and was switched to or, was to clarify that 1 and 2 did not necessarily have to be a part of the same proceeding.
So what I'm hearing is, my thought was in adopting this that we're compromising and making it better, and what I'm hearing from Maryland Multi-Housing and a bunch of the other people is this amendment makes it worse, that the House rejected this amendment, and specifically the striking of this and making an or, that this amendment actually makes the bill worse, and that specifically that they're opposing this amendment.
So switching the and to the or, I did talk to editing and review for it, the conjunction. So as it would be interpreted right now, with the and or with the or, is that 1, for a proceeding to evict or terminate the tenancy or housing subsidiary of an individual, you could bring, a covered individual would get representation for that. If they had if tenant number 2 had a proceeding for a violation of any of the following provisions, they would get representation for that because they're not connected. If the intent is to say that they need to be connected, there would be additional clarification other than a conjunction to make that specific, because whether it's the and or the or, that's not making the distinction.
So where are these amendments coming from? Like, who wants these amendments?
Senator Hedelman.
What is the point of these amendments?
It's just a clarification, as counsel said.
Well, they don't, from what I'm hearing, the clarification makes the bill worse. That striking that and or the or, not connecting it, or makes it worse.
How is it worse?
Well, she just went through it. She's explaining that it makes it worse because if they're not, if you don't have them connected, if you make it an or instead of an and.
The intention was for them each to be considered separately. This is the clarification. The intention all along was that, and that this is just a clarification of that.
Well, that's what you may have intended, but everyone who read the bill thought the end was better, and by going to an or, I think it just pushes the bill further towards the tenant side. So that's what I think the problem with these amendments.
What are you saying? You're saying to clarify. Why are you saying that?
So as originally drafted, allows for legal representation to evict or terminate the tenancy for a violation of retaliatory action rent without any funding source because of failure to pay rent proceedings solely or simply legal issues. Yeah, I mean, I think this is a big policy change, doing this. And I think this actually pushes the bill. This is a big policy. This is not clarifying.
This was the intention all along. That's why we're making it explicit now.
So with the and, under the current version of the bill, 1 and 2 are not connected. It's for a judicial proceeding, for a judicial or administrative proceeding to evict, period. For a judicial or administrative proceeding for a violation of any of the following, period, is how it could be interpreted. And that there was confusion that was happening, which is why why the request came in to switch to or, to make it clear that 1 and 2 weren't connected, but under the and, they are not connected. I could draft an amendment to say that they are connected. I would do it in a clearer way to avoid the conjunction confusion. I think it's because there's the clause beginning in line 18, including the first appeal, that's creating the confusion. Yeah, so there are policy concerns for connecting 1 and 2 or not having them connected, but as currently drafted, they are not. That you can have 2 different proceedings.
So what did the House do in this?
The House didn't,
I don't know what the House has done.
My understanding is the House bill has an or on it.
and my understanding is, I'm not sure this section is in the House bill. I'm not sure.
No.
This is just representation for
Also treated
appeal.
differently, the community council said no.
I'm very confused by this. When I read the word "and," I think you have both. So if in a triathlon, you run and you swim and you bike, it doesn't mean you do one of the three, it means you do all three. So "and" to me means everything on either side of that word is included.
So as drafted, it's under the program, MLSC shall provide a covered individual with access to legal representation by a designated organization for a judicial or administrative proceeding to evict or terminate a tenancy housing. So this is just a list of all the different times that MLSC would be required to provide representation. The list of all the different types of proceedings. So if you look at paragraph 2, that leads on to the next page. On page 5 of the bill, line 4, you see the appearance of the conjunction "and" again. The "and" is not specifying that the proceeding would need to involve all of these different types of violations. It's just, it could be any one of these types. It's just, it's a stylistic
Well, let me just
drafting.
say, it really does make a change. I was on the task force, and I indicated that I'm totally supportive of counsel for eviction proceedings. Because in those proceedings, the landlord's proceeding against the tenant, and the tenant is the defendant, and the tenant needs counsel to represent the tenant in defense of the eviction proceeding. But these other proceedings in 2 are proceedings in which the tenant is going to be the plaintiff suing the landlord. And I disagree that we have an awful lot of civil Gideon that's waiting in the wings that we need to be concerned about. Before we start paying for counsel for people to sue people, we need to finish paying for counsel for people to defend themselves.
Right,
So there are two fundamentally different things which are being joined here by this "and." I can support the first, but not the second.
So that's a policy consideration, and I'm not arguing in favor or against it. I'm just saying that the conjunction on page 4, line 22, the "and" to the "or," was trying to clarify what the "and" was actually doing, because there seemed to be confusion that 1 and 2 were connected with the "and," even though they're not under the current bill without the Senator Hedelman's amendment. If there was a proposal to connect them, to say that it must involve a proceeding to evict or terminate the tenancy of the housing subsidiary of a covered individual, that can be drafted as an amendment. That can definitely be done, but that's not what the bill does currently, and it's not what Senator Hedelman's amendment does.
Yeah, I just think it may not have been their intent to draft it this way, but it's a huge change. It's going to dramatically increase the number of cases by changing that from an "and" to an "or." So it's going to go from basically every case now is going to get picked up under this. And my phone's sitting over here blowing up as everyone's watching this, that this is a huge, substantial change, this one amendment. So it's not, they're not saying it's clarifying, and I'm also getting word the House interpreted it differently and left it as an "and."
Yeah, I've since found out that the House left it as an "and" as well. But again, I'm going to leave it to counsel, to the interpretation. It does not. We estimate that it will be about, first of all, the appeals, and I can speak to what my colleague from Baltimore County talked about, are for very specific cases that result in eviction. So they are rent escrow cases, and they are for launching an affirmative defense and eviction-related cases if a landlord is trying to evict somebody by turning off utilities, turning off the water. And so I think that's entirely appropriate in a case like that for us to be providing representation. And we've sort of estimated how many cases that is. It's not everybody. It's 5 very specific situations. And we estimate, I mean, I have a cost estimate and roughly about, I'm just looking now for how many cases we think it is, but it's pretty narrow. And again, the vast majority of cases are not this at all. And the appeal process, too, is burdened with risk for the tenant because they have to pay if they don't win. So there are disincentives for them to go ahead with an appeal. You have to post an appeal bond. So this is not just, willy-nilly put it in there. You have to really seriously think and really seriously consider your case here.
Senator West.
Thank you. I think my colleague is misreading the language in 8-904. It doesn't only cover appeals. It says the coordinator shall provide for access to legal representation by a covered individual for a judicial or administrative proceeding, including the first appeal. So we're not only talking about appeals here, we're talking about the case in chief plus an appeal.
Correct, but I was referring to the and/or issue.
Well, I don't think that changes the fact that the section covers the underlying case plus the appeal.
Correct.
And if you tell people they get free counsel to sue landlords, there's no stopping it. The tenant community will realize that if they want to sue their landlords, they got free counsel, and they get an appeal at no cost to them. So any tenant who wants to cause landlord trouble, and let me talk about the 2.1, retaliatory action by landlord. So if a tenant apprehends that the tenant's not going to be able to pay the rent, the tenant simply files a complaint to the landlord about something, and then when the landlord sues the tenant countersues that this was a retaliatory action because the tenant filed a complaint. And the tenant can do that with free legal counsel. So we're talking about vastly multiplying the legal proceedings which are going to occur if we give free legal counsel for the various subparts of 2.
Sorry, let's go Councilwoman and then Senator Castley.
So to show the intent that they were not intended to be connected, I guess this could. So page 5, lines 13 through 14. This specifies when MLSC shall ensure that a covered individual receives access to legal representation by an attorney in a proceeding as required under the subtitle. It's MLSC, a designated organization determines that a proceeding on behalf of a covered individual should be initiated, period, which, again, it's not explicit as the and or the or conjunction issue, but it's going to show that a violation of any of the following provisions, that an action could be brought specifically for those, that it does not need to be connected to an eviction proceeding, which is specified in line 12. It does separate it out there as well.
So Senator Castley and then Senator West.
Counsel, your explanation on page 5, line 13 and 14 would have this would cause every attorney that got involved in this to potentially violate the rules of professional conduct, because you have a duty to your client, not to what the law is providing you reimbursement for. So if you're an attorney and you're in on one for the tenancy matter, and the tenant says they want to pursue something else, and they're entitled to it under this, and then for you to say, well, I disagree with my client, I don't agree that you can say, well, that's not a very good case, I'm not going to pursue it, which is really what we're saying here. And if the law provides that there's funding available for it, and now we put the attorney in conflict with the client's desires. I think Senator West is absolutely spot on that to try to guess how many people will pursue these actions based upon past practice is just illogical. Having represented many clients on reduced or free legal expenses, there's clients are very willing to spend attorney's time if they're not paying for it and pursue all kind of matters that border on frivolous, but not that don't cross the line of being in bad faith. So I think it's, this expansion is not good. I have my specific question is, which I've really not gotten the answer to since this hearing started, since this whole bill started, and now I see the amendments right there. We're still calling this a right to counsel. So I get into court with my client, the landlord, the tenant shows up, they don't have one of these lawyers under this program, then it appears from this bill that the judge says, we cannot move forward, there is no lawyer here. They call the program, they say, we don't have any funding for this. Then the judge would say, well, we can't do the eviction proceeding because that would deny the tenant the right to legal counsel. Why is that not how this reads right now? And is that your intent to do that?
Opinion that says it's a right to access to counsel. So just because you are filing there does not mean that that each person shows up and is entitled to an attorney.
Is the AG opinion based upon the original bill or based upon this amendment? Because this amendment is a substantial amendment to the bill.
I'd have to go back and look. But it's
Okay,
the
so it's
same
based upon the
principle.
bill.
It's the principle of whether a right to counsel is a right to access or whether like it is in a criminal.
Well, the only term that the courts know, right to counsel means right to counsel. It doesn't mean maybe that you could get one if the fund's available. Right to counsel means right to counsel. And if we look back at the lawsuits with regard to counsel in the preliminary stages of the criminal proceedings, right to counsel meant just that. And when the state didn't have the funds to move forward, the court said that is not an excuse. The money the counsel will be there, or we're not moving forward and we'll dismiss these cases.
Okay.
To me, that's where we stand right now with this. If the way this reads, we're gonna put a gun to the taxpayer's head and say, if you want to have evictions or any of these other proceedings, you've got to pay for it. And I don't see anything in here that would to have this in any way different from that decision.
So since we are going, we're going to table this for that work group, but so I don't want to get too down into the weeds on that stuff. But let's go ahead.
So my problem is adopting an amendment that we don't know. I'm trying to find out what this amendment means, because then we're going to have to draft amendments to the amendment.
Sponsor, we're going to waive off the amendment for now.
Okay.
We'll evaluate the material as we move forward. So let's go ahead and Senator Castleton, if you're concerned, we're not going to. You're okay. Got it.
Okay, I'm fine. Thank you.
Okay. So Senator West, and then we're going to go to Senator Bailey, and then Senator Huff.
No. If we're going to move on to another bill, I'll save my comments for next time.
Senator Bailey.
Thank you. I just think that it's important that we should, if we talk about this, we should call this what it is and call it the way we see them, right? We should use an appropriate title to this bill. It should be landlord and tenant, eviction action, right to pro bono counsel, right? I think that is very important. They already have the right to counsel, right? We should call this what it is.
I was just looking, and actually, I like what the House actually did a good job on this bill, because theirs is dramatically different. First off, they have it so it looks like it's just Maryland Legal Services that's doing this versus all these little nonprofits. And the reason I don't like these nonprofits is this cycle down here where these groups come in, they ask for a bill, they lobby for it. Most of them aren't even registered lobbyists. And we go ahead and pass these bills, and then they get the money from it. So they actually struck all these nonprofits out of there and says it's all through Maryland Legal Services Corporation, which I think is good. And then their version of 8904 is dramatically better than ours. It's basically just dealing with evictions. They struck a lot of this language out. So we should not, I'm glad we're not adopting this amendment. And actually, I would prefer we would work off the House, because the House actually made, I think, improvements to this. If you look at it, they leave in the end. They left that in. They did not go to an or, and they just did to evict. And they struck out terminate the tenancy housing subsidy to evict a covered individual, and then they lay out the rest of it. So, I mean, I think the House version is better.
There's a major structural problem with the House version. MLSC doesn't provide direct legal services. MLSC is set up as a grantor agency. What they do is they get funds and they disperse those funds to lots of different legal services organizations. So the House is quite problematic because that's not what they do. That's why we have to have a designated organization needs to be a key element of this bill.
I thought
Yeah, they do the distribution.
We just write in Maryland Legal Services Corporation.
We have in the past.
We did this under the attorney filing fees and everything else. We just wrote in Maryland
You can put
Legal
'em on if you want.
Services.
You can put them on.
My memory of this, when we raised the civil filing fee and everything else, we just wrote in Maryland Legal Services. We didn't write in and/or other nonprofits. I don't know that we've ever done that. I've always remembered when we created new filing fees, we just wrote in Maryland Legal Services Corporation. And then they dole out the money. So I think the House bill is correct. You don't have to specify and say, when we've done it every other time, we specified Maryland Legal Service Corporation, they doled it out. You don't specify all these other nonprofit agencies. I understand why the nonprofits want the bill, don't like that.
We are going to be, it'll be workshopped tomorrow, so hopefully we'll be ready to discuss again tomorrow afternoon. So Senate Bill 201, Senator Walsh, and we are working on something that is not ready for prime time, or is ready for?
It'll be ready tomorrow.
Tomorrow, okay. And then, so for Senate Bill, the 210 and Senate Bill 311, I know we're doing a workshop on that. So that'll start tomorrow as well under under Vice Chair Walsh. So let's go on to Senate Bill 397, Senator Carter. That's Josh.
This bill authorizes diminution credits to reduce the term of confinement of an inmate who successfully completes certain educational programs. The deduction allowed is 90 days per program completed and is in addition to any other deduction awarded. The bill would apply prospectively only. So there are two amendments. You have one of them in your packet. That's number 803529/1. This is just a clarifying amendment that strikes the words "in advance" to make it clear that the inmate has to complete the program before they're awarded the credits. The other amendment, you don't have it in your packet, but the amendment would conform the bill to the version of the bill that passed the Senate last year. That's Senate Bill 922, which you should have in front of you. The amendment would do two things to change the current bill. First, it would add a provision which excludes from the DIM credits any inmate who is serving a sentence for a sexual offense for which they are required to register as a sex offender. And additionally, it would reduce the amount of the DIM credit from 90 days to 60 days or 40 days for an inmate who is serving a sentence for a crime of violence.
The in advance, if we're going to do, if the in advance language makes sense, it also appears in 922 from last year. So you'd want to take that out. I mean, if we're going to take that out, if the point was brought up, that's all.
Committee, hopefully the third time is a charm. We've passed this bill twice in this form, I believe. I think that it's probably an exercise in futility to argue that the original bill that calls for the 90 days for a bonus credit upon the completion of a program, I feel that it's futility because sadly I feel that there are a lot of members here that have somewhat of justice, DIM credit, decarceration fatigue this session. It's just sad that we didn't have that type of fatigue as we were piling on these types of things that were allowing Maryland to become one of the most carceral states in the country, and one of the greatest purveyors of mass incarceration. But, you know, I want to pass the bill I know the House is working on a version of the bill. The House twice, I believe, no, not twice, just once. The House once passed the bill straight. Last year, we passed the bill, I think, in this form, and the House wasn't able to get their bill out. But I know the House is working on a bill, and hopefully we'll be able to get something done. And for those that don't remember or maybe weren't here, this is probably one of my favorite bills, and I'll just briefly explain why. Part of our problem is that we aren't doing enough to rehabilitate people when they get incarcerated, and then when they're released, they often come out with no skills and no ability to really be productive. And so we go about the business of allowing DIM credits for anything, for all these things that, such as, services, jobs, mopping floors, cleaning up, picking up trash, working in the kitchen. But this bill gives a bonus credit, not just because you did something all day, not just because you participated in something, but because you actually got your GED, because you actually got your bachelor's degree, because you actually got your associate's degree, because you actually got your HVAC license. So these are the very things that we need people that are incarcerated to do so that when they come out, they're employable or possibly even in a position to get a license or to start a business so they can work. And one of the biggest problems that we've heard, and know is true, year after year, is that once people are tainted and stained with the stigma of this criminal conviction, this felony conviction, this record of incarceration, there's nothing for them when they get out. And so there's very little for them to do to be welcomed back into society, and oftentimes getting a job is almost impossible because of the record. So I just really believe this is one of our better bills that we've ever passed. I know that there is will to reduce the number of credits that someone can get for a bonus because they completed a BA or a program. I just want to say that whether you're in prison because of a drug offense, or whether you're in prison because you committed what's considered a violent offense, the accomplishment of getting a license or a degree or a certification is still the same. And so I don't really agree with the concept that we should limit the credits based on the underlying offense. That's been determined when the sentence was happening, and that's already something that's being done through the system where certain offenses generate less DIM credits than other offenses. But this isn't really the same thing because this is more of a bonus. This is saying, hey, we want to incentivize you to complete these programs, not just to sit in there and never learn anything and never complete it. So all that being said, I will defer to the will of the committee, but I really do believe fundamentally that, even if I'm not incarcerated, but if I were a person that had a felony conviction outside of incarceration and I complete and get a degree, my degree should be no less because of the fact that I was once incarcerated. In fact, I should probably be given more credit because I have gone about, the trouble of getting a degree. And I have a difficult past. So just saying, whatever the committees will, but I'd move. Well, if you all want to talk about it, that's fine.
No, I appreciate it. I appreciate Senator Carter. I really appreciate. This is actually one of my favorite bills too. And I really like the work that the discussion we had last year, and in the context of JRA, which as you mentioned before, violent offenders still get 20 days, up to 20 days max a month, and then for nonviolent offenders you can get up to 30 days a month, and this is in conjunction and on top of that. So we've made some significant progress, and yes, incentivizing people to arm themselves with tools and skills so that they can succeed when they get out is great. And I think that what we're doing here is amazing work, and I appreciate you bringing it up, and I know that the amendments claw it back for folks that are, James and Josh, you can clarify again just one more time what the amendments do, but what we did last year and what this amendment would do was essentially, it's basically carve out for sex, if you have to register for a sex offense, all right, ineligible for these new DIM credits, and what else? You're eligible, but you just get the reduced number, yeah. Sorry, can we get Josh?
Yeah, so if you had to register as a sex offender for the crime which you been incarcerated for, you would be excluded entirely. And if you were in for a crime of violence, you would get 40 days dim credits as opposed to 60 days for everyone else.
Yeah, and for the sex offenses, I mean, we're not touching any other diminution credits that apply, just for this bonus.
No, just this new credit.
Got it. All right, Senator Huff.
I was going to say, yeah, as far as, I remember this bill because I got a nice campaign mail piece because I voted for this bill back in, I don't know when it was, 2014. So this has been around a while. The problem with the bill as it comes in unamended is it doesn't take into effect, when we did justice reinvestment, we went 30 days for nonviolent and 20 days for violent. This bill with the 90 was prior to that, which that was a 10-day increase for both. So for violent offenders, justice reinvestment doubled what you could get, and for nonviolent, it added another 10 on top of it. So it was a dramatic expansion, and actually, just to talk about a prison population in Maryland, it was already declining when justice reinvestment was happening. Maryland was the only state that did a justice reinvestment with a declining prison population, and it's declined since then. So, but I think that the amendment's good because it removes the sex offenses, but also the amendment that we put on the floor last year matches to our current scheme because the amendment is 60 days for nonviolent and 40 for violent, which matches to the 30-20 that is under current law. So I've always thought this was a good idea to incentivize people to finish programs. I just think in light of the dramatic expansions that we've already done, I think to bring it back a little bit, it's not because of, for me, hesitancy on the floor or whatever. I just think it's in light of the bigger picture that this bill was introduced prior to that and that now the scheme is, quite frankly, a lot different. And so we should still incentivize them, but I think the 60-40 makes sense. So I would make a favorable on the amendment. Motion.
His hand up before, I didn't know. But you seconded it, so we got to. Go ahead. Okay. Do folks want a roll call on this, or is it fine by voice? Oh, sorry, the ayes have it, so it's adopted. Okay, great. Now there's been a motion to move the bill. Sorry. We have council's flagging something, so just want to make sure we get it.
We also have the clarifying amendment to just make it clear that you have to complete the program before you get the credits.
Is everyone okay adopting that clarifying amendment? Yeah. Is everyone okay? Everyone understands? Got it. It's adopted. So now the bill's before you as amended with amendments. There's been a motion for a favorable. It's been seconded. Do folks need a roll call, or is everyone okay? Everyone's okay. Great. Excellent. The bill passes as amended. Sorry, Senator Castley.
I just want to ask Senator Carter because, Senator Carter, just a question for you really quickly on this one, because I'd really like to see it, because you made the statement on the floor and then you made it here that we're either the most or one of the most incarcerable states, and we're also a leader in mass incarceration. I'm just really curious to see the study in that, or something that justifies that, other than just us saying it, because I haven't seen that in a study yet. So if there's something that you can share, I'd really appreciate it. Thank you.
The two studies that a lot of people have been using this year and I think somewhat last year, because it was last year that the report came out that said that Maryland incarcerates a higher percentage of black men than any other state in the country. That was last year's report. And then the other thing, so when I said, I didn't say I said we are one of the most carceral states, because I believe that we are because of that. Also because of a lot of these initiatives that we're changing now that we've had in place, like the fact that we wouldn't let people out of prison because the governors, for the most part, wouldn't allow parole, even when people were sentenced for life with parole. We are still one of the remaining. No, listen to me. No, you.
I just wanted to see where the studies were, because we say things like this, and the public hears. And I'd really like to see the documentation.
Let's give her a chance to respond. Yeah.
I'm finishing my answer. We are in a minority of states that continues to automatically charge children as adults. We are in a minority of states that are now finally dealing with this concept of allowing children to get the review of sentence when they're not children, but when they're sentenced as children. Many other states, the majority, have already taken initiatives to not allow that to happen. So when I make that statement, is because we continue to have laws and policies in place that the majority of states have shifted away from over the last decade or so.
Incarcerable, that says if you have 6.5 million Marylanders and the percentage that we put in jail is higher than per capita than other states. That's what that would mean. I'm just wondering, I'd like to see that study. This is that, and then to say we're a leader in mass incarceration, that would say that for per capita, we incarcerate more people than the rest of the country. And that's what, I haven't seen those figures. And because that's what you're saying. When you say we're incarcerable and a leader in mass incarceration, you're saying per capita that's the result. I just would like to see that because I've never seen that. Thank you.
Maybe somebody could take my numbers and stats there. I was just saying, maybe somebody wants to take my position and volunteer. I've been on that Justice Reinvestment Board for like 4 years, and my time is I feel like I'm good there. So they have all these stats and studies, and you get to reinvest the money that we used to put in prisons, and now we're putting in the community. So I would highly encourage, or you get the documents.
We'll work on that reassignment if you like. We'll see. Before the summer, though, right? Before we adjourn.
I got a police volunteer for that one.
And we've got one for the Police Training and Standards Commission as well. All right. So we'll now go on to Senator West, Senate Bill 445. Just a note recap. So Senate Bill 397 passed with amendments. Senate Bill 445. Folks just have some questions on that, but you've got an amendment. Can we go over what the bill does? So Josh, and then Senator West, I guess we can talk about your amendment.
This bill requires the Motor Vehicle Administration to adopt regulations establishing standards and requirements for aftermarket safety glass replacement that meet or exceed the standards and requirements under the Automotive Glass Replacement Safety Standard established by the Auto Glass Safety Council. The amendment in your packet is number 983128/1. This bill conforms the bill to the House cross-file, which is already passed, and it clarifies some of the requirements of the regulations that the MVA would be required to adopt.
So let me explain it briefly. This was Delegate Barvey's bill, and he asked me to cross-file it, which I was happy to do. So time was, if you got a nick in your windshield or a crack in your windshield, they would simply take the old windshield out, find the correct windshield number, and then put the new windshield in, and that was the end of it. These days, windshields have all sorts of electronic stuff in them, and it's not as simple as simply replacing a windshield. You have to calibrate the new windshield to an infinitesimal extent in order for the windshield to work properly. So these national organizations have established standards which all windshield companies should follow in installing new windshields. And if you get it wrong and the windshield pops out when you have an accident, the people in the front seat also pop out and people die. So it's very important that the windshields are installed properly. So as originally introduced, it was one group of people with the standard, and apparently there is a competing standard out there, and they came in and said, you haven't taken our competing standard into account. So they worked on it, and this amendment is the consensus view of all of the windshield people who know what they're talking about, which I do not. But their view is this is the language we should use. The House bill incorporated this amended language, and it passed the House, I think it was unanimously, the other day. So we ought to use the same language that the House used for our bill. And it's a good bill because we ought to provide that people who are installing windshields use the proper installation methods and do it right so the windshields won't pop out in an accident and people won't die.
I have a question for Josh on this one. So I'm looking at the amendment. So I don't know anything about this. I had a company who I don't know who they are, but they're in Carroll County who does manufacture glass, and they sent me an email. And they were concerned about it as it originally came in. And they just said it needs to go by the federal standard. I hand it to you, Josh. I'm concerned because this says, and this auto glass safety replacement safety standard. I guess what I just want to make sure we're not doing is I want to make sure there's not some glass manufacturing company out there that does it one way and we help them inadvertently and yeah, because I just haven't heard of like a rash of issues on this. So does this the amendment? This looks like he just the email I got. He just said it would made sense to me. That's why I showed it to Josh. He said just go by the federal standard. I don't know if and this auto glass safety trade. I don't.
So my understanding, and I'm not an expert either, but is one of the points of the amendment was to try to hit both the materials that are used and the process of installing them. So, the use of motor vehicle safety glass that meets the ANSI standards and the federal standards. So that would be for the materials that you're using. And the meet or exceed the standards and requirements of the American National Standards Institute for auto glass replacement safety. So that would speak more to the installation of it, which I think is where what Senator West mentioned, that nowadays a lot of these cars, they have smart technology that is using cameras on the windshield, and if you don't install it correctly, the cameras might be calibrated poorly and they might not be picking up what they're supposed to be picking up. So I think that is one of the ideas behind the amendments, is to kind of hit both of those components, the materials and the installation.
Can we do this? Could we just hold this for one day? Because I don't know what Z26-1 and all these different standards are numbering. The glass guy that sent me something listed a federal code on what is required of these glasses, this glass, which is not what's in the amendment. And I don't know enough about it to. Okay, I'll run it by him and ask.
Yeah, I think you're going to find this is what he's looking for.
Okay.
All right, so we'll hold it for a day. We'll put it on tomorrow. Hopefully you have a resolution. All right, Senate Bill 497. That's Jamie.
Senate Bill 497 repeals statutory provisions regarding the Juvenile Services Education Program within the Maryland State Department of Education, and instead establishes a Juvenile Services Education Board within DJS. The board would be responsible for overseeing and providing for educational services to all juveniles who are in a residential facility beginning July 1st, 2022. The board must oversee and approve all educational services to all juveniles who are in a residential facility, and DJS has the authority and responsibility for implementing the juvenile services education programs in the state. Beginning in fiscal 2023, the governor must include sufficient funds in the state budget for DJS and the board to implement the bill's requirements. The bill also alters membership of the correctional officers' retirement system to include an individual serving as a DJS direct education staff member on or after July 1st, 2022. There is an amendment in your packet. It alters the provisions relating to inclusion in the correctional officers' retirement system by or for the juvenile service education employees, and instead provides that they would be part of the state employees' pension system. Evidently, there was an issue with including those employees. There were specific requirements, I think, through the IRS for including certain individuals in correctional officers' pension system.
All right. So can we adopt this amendment? This is the sponsor's amendment. Is everyone okay with doing that? All right. The amendment's adopted. So now the bill's before you is amended. Fairly straightforward. Sorry, go ahead, counsel, go ahead.
Sorry, I had just gotten an email during the voting session from one of my counterparts in finance, and they had actually suggested changing the some uncodified language to deal with the pension issue to say that all employees who are transferred to the Department of Juvenile Services as a result of this act shall be transferred without diminution of their rights, benefits, employment, or retirement status. So that would be in the uncodified language at the end of the bill. And the suggestion was to put that in Section 3, which appears on page 14, and that is between lines 9 and 13.
Approving, that is Section 5, it's
Oh,
replacing
you know what?
that.
Right, that should be the new Section 5,
Right.
you're right. Yeah.
Do we unadopt it and move?
Well, we adopted it anyways. We
So
adopted
there was a strikeout that you guys adopted as well that
Yeah,
put
but I'm
them in.
not, this
so-
doesn't say what he just said.
what, the Section 5?
Yeah, it's different. This says, this is more specific, and theirs is more general. Seems to me the more general is better, because if we're wrong on the specific, we screw these people over. If it's general, we say, don't impact your pension. It's got to be, right? That's what they want. They want their pension. It sounds to me that the finance person's saying, this is too specific, and if we say the wrong magic words and it can't work, then they're screwed.
So the new language would be, all employees who are transferred to the Department of Juvenile Services as a result of this act shall be transferred without diminution of their rights, benefits, employment, or retirement status.
Senator Jackson.
So I'll thank you, Mr. Chairman. I'll say a couple things. One, I understand from the amendment, what the amendment is trying to do. The folks are no longer in corrections. They're now part of the education component. So I understand that. But I think with what was just mentioned by Jamie kind of gives me a bit to pause. When I first became when I became a delegate, I'm not sure if it was my first year or my second year, I put forth a bill to add some members of the Department of Public Safety to the 20-year retirement system. And unbeknownst to us, we actually created a challenge for some of those folks. And Senator Sidnor can attest to that. But it was an unintended consequence. So I think we need to be, I think we tried to be too specific when we did that. And I think more general, I'll agree with Senator Castley, the more general is the better. You know, we don't have one umbrella, you know, for retirements anymore. So we have to be very careful when we lump folks in. So been there, done that, and I think we need to make sure that we get it right. But great bill, I support it. Thank you.
Excellent. Well, thank you. We'll endeavor not to repeat the mistakes of the past. All right, so do you want to say anything, or you got it? All right. All right, so is everyone okay adopting that? So that would replace, so the amendment would be to strike Section 5 and replace it with the language that Jamie. Is everyone okay? All right, great. All right, so now the bill is before he's amended. Further discussion on the bill? Senator Castley.
I mean, we looked at the history of this. This is not a partisan bill. This is about putting this educational responsibility where it will benefit these kids most. That's all I think any of us care about. Where does this fit? It's currently with the Board of Education, or the educational establishment, because we moved it there. Because we were told to move it there, because none of us are experts in this, and we moved it there. And now the people who told us to move it there are saying, now move it back. And I know we have opposition in our file from University of Florida, the expert there, who's saying this is a big mistake. I don't know. He's the consultant. I got it. But I mean, I'm going to support this, but it is somewhat disconcerting because the same people who said move all this over are saying move it all back. And I really hope that in this confusion, these kids don't get screwed over, because educating these kids in who are being detained is really important, that we don't screw them. They're already a step behind in life because they're incarcerated. And so they ain't going to come out. There's going to be some bad consequences here. And I just don't want to compound that. So I hope we're doing the right thing. That's all I want to say.
Thank you, Mr. Chair. This is going to be twice, Senator Cassidy. I'm going to certainly agree with your sentiment. So my time in the House I spent on one of the subcommittees I served under was Public Safety and Administration. But prior to that, I worked under one of our previous governors, and my task there was the director of leadership development and public safety. And one of the things that I noticed right off the bat when I visited the Department of Juvenile Services facilities, I visited every facility in this state that deals with public safety, every parole and probation officer, whatever. But the one thing that I saw that was consistent with the Department of Juvenile Services was a lack of consistent education or a uniformity in the education, even though it was under Maryland, but the MSDE, even though it fell under that. Over the last summer, there are at least 3 members, Senator West, Senator Carter, Senator Smith, I believe, that are part of the Juvenile Justice Reform Council. And out of that extensive work that was done, what did we end with at the end? The thing that we all walked away with, proud of the product that was created, but it still was unfinished. And that unfinished piece dealt with education. And 2, yeah, well, yeah. But education. And until we can drill down and make sure that we are focused on that. And it made sense, I guess, when the decision was made to put it on the MSDE. It made sense, but I'm not sure. Well, it wasn't working. So I am with you. I am spot on that. I can't wait to, I don't say that about many task force or work groups I've been a part of. I can't wait to get back to this task at hand, because it is so vital when we have a captive audience, literally, and no pun intended. We can then try to get these young folks focused on, what's important. And with juveniles, last thing I'll say is this: one of the biggest challenges, we don't know where they are on the education scale, according to their age and their level when they come in, and the fact that they're not there for extended periods of time. So it's a very dicey circumstance, but I think this is part of the challenge that that we have to meet, and some of us are eager to get to it. So I want to make this one right, and as we move forward. So thank you.
Thank you, Mr. Chair. As Senator Jackson just noted, I was on the Juvenile Justice Reform Commission. We've met for about 1.5 years now, and we finally finished up. I go back to the first meeting we had, in which there was a young man who had been in the system and who had been appointed to the commission. And he made the short statement that the education that he received in the system was totally useless to him because they were all college preparatory courses. And he said, I know I'm not going to college. They didn't give me anything that I could use in my life. I had a conversation with him after the meeting, and he elaborated on that. So what I've been harped on all summer in the Juvenile Justice Reform Commission, and I'm happy to see in this bill, is it requires the educational program to meet the special needs and circumstances of the juveniles. And then on the next page it goes on and says, the department shall develop an educational plan for each school-age juvenile in custody for more than 4 weeks that's designed to meet the juvenile's individual needs. So no longer are we going to have kids in there forced to take college preparatory courses if they know they're not going to college. They can get vocational courses which are going to help them in the life that they will lead once they get out. So I think this is a good development. I plan to vote in favor of the bill.
All right, thank you. That's great. Thank you both very much for that. So Jamie, no other amendments, right? Nope. All right.
The House may, they're still working on it.
Yeah, but I get it. All right, so now the bill's before you as amended. Is there a motion? Motion for favorable. It's been seconded with amendments. Do you want to do roll call? Is everyone okay? All right, everyone's good. All right, great. So the bill passes as amended with amendments. All right, next we're going to go to Senate Bill 623.
The amendment, and Senator, I know we had discussed the language from the criminal law article that exists. I'm just going to forward that language out to the members of the committee right now. I didn't have time to prepare an amendment for it. But in your inboxes...
Can you also just provide a brief overview of the...
Right. You should be getting a copy of it. So in the current provision of the criminal law article pertaining to the child pornography statute, there is a provision for an exemption for, I'll just read it, it's section 11-210 of the criminal law article, and this pertains to child pornography. So it's a person having a bona fide scientific, educational, governmental, artistic, news, or other similar justification for possessing or distributing prohibited matter is not subject to the prohibitions and penalties imposed by this subtitle. So that provides a fairly more broad exemption than the research exemption under the current bill. So I guess the proposed change would be to provide that the prohibition does not apply to a person having a bona fide scientific, educational, governmental, artistic, news, or other similar justification for possessing ransomware.
All right, the amendment's been moved and seconded.
And there's also the...
hold on, just real quick. Go ahead, Council, and then I want to go to Vice Chair.
Just to recap, there's also the amendment from Senator Lee to conform to the House side. That would lower the penalties from 3 years, $10,000 to 2 years, $5,000.
So let's first consider this amendment, that you've ripped from the child pornography statute. So it's been seconded. Is everyone okay adopting that? Okay, it's adopted. Vice Chair.
And I just wanted to thank the sponsor on this. Turns out, I think the sponsor and I were part authors of the provision that Council found when we were delegates on the Judiciary Committee together. And so I did have First Amendment concerns with the bill as it came in. I apologize to the sponsor for expressing that harshly yesterday, but I appreciate working with the sponsor to get this right. And so thank you, Mr. Chairman, for allowing me to vote for the amendment. With the amendment, my intent is to vote for the bill. So thank you to you again, Mr. Chairman. Thank you to the sponsor.
All right, so we just have one more amendment, which is the to conform to the House, so it just lowers the penalties. Can you just highlight it one more time, just so everyone knows?
So the current penalties under the bill provide for 3 years, $10,000 for the ransomware possession violation. This just drops that down to 2 years, $5,000.
Is there a motion for the amendment? Motions. All right, it's been seconded. Is everyone okay with that? Okay. No further amendments, right? All right. Further discussion? Senator Lee, you want to say anything or no? All right. There's been you want to say something? Okay, go ahead. All right, we got a motion and then we got a set.
Yeah, I mean, I'm not as easily placated as Senator Wallstreicher is. I think the bill is still unnecessary, and I think the First Amendment concerns are not addressed sufficiently. I think that it still puts a chilling effect on the industry and without sufficient cause. So, thank you.
I definitely feel more comfortable with the amendment, and I know we discussed earlier during the last voting session an article that was passed that was just published in Bloomberg Magazine and talks about the democratization of this type of technology and how accessible it's become and how it's proliferated. So with that, I'm comfortable voting with it. But we've got an amendment, we've got a motion, it's been seconded. So I guess I assume we'll do a roll call on this. So, go ahead.
Vice Chair Waldstraker.
Yes.
Senator Lee.
Yes.
Senator Castley.
No.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yeah, yes.
Bill passes.
The bill passes. We'll now move on to Senator Carter, Senate Bill 625, and that is Heather.
Senate Bill 625. This bill alters the circumstances under which an individual may be disqualified from jury service. The bill repeals provisions that disqualify an individual who has previously received a sentence of imprisonment for more than 1 year, or who has a pending charge for crimes that are punishable by imprisonment for more than 1 year. Instead, under the bill, an individual is not qualified for jury service if the individual has been convicted of a felony and is currently serving the sentence imposed for the conviction, including the term of probation. There is one amendment in your packet, Senator Smith, 658877. Under the proposed amendment, it specifies the biggest change is page 2, lines 10 through 13. An individual is not qualified if they have a charge pending in federal or state court of record for a felony. Lines 7 through 9 is just rewording for clarification the current bill. So, yeah, lines 10 and 13 are the change.
So go ahead. Question on the amendment. Go ahead, Senator Castley.
Yeah, I mean, so the amendment makes it a little bit better, but look, you could still, even with this amendment, you could have been convicted in a federal or state court of a very serious misdemeanor and currently serving the sentence. I mean, actually, I guess the amendment makes it worse because right now, the way it's written right now, it says has been convicted in federal or state court of a crime punishable by imprisonment exceeding 1 year and received imprisonment for more than 1 year. But we're still, the way it comes out now, you're on probation for, you did 5 years on a misdemeanor and you still got probation time to serve, and you're sitting there on a jury, you did a serious assault, and now you're on a jury for a serious assault, and you're still serving time for that. And then in number 5, has it? I'm sorry, 4 is already convicted and still serving. And number 5 has a charge pending, so for a felony charge, but you've got a charge pending for 4 serious misdemeanors for which you could total up to like 40 years. And you're sitting in court, and you're going to go into a jury to judge somebody while you're sitting there up on serious misdemeanor charges. I think at some point we want to put people in the jury box. I mean, I'm sort of chuckling because this just seems unbelievable to me. I mean, you want people in the jury box who have demonstrated a clear intent to live by the rules of society, the laws that we're asking them to impose on other people. And now we've got people sitting there, and on number 4, we got somebody sitting there who's still on probation, hasn't even demonstrated that they just walked out of prison, and now they're sitting there on a jury, and they're still on probation. We don't even know if they're going to recidivate yet. This is.
Those are people who are disqualified. If you go back up, and unless I'm reading it wrong,
Mr. Chair. Thank you, Committee, I just wanted to speak a little bit about the efficacy of this bill. And doing some research to look back, juror disenfranchisement happened in the 1960s, and it happened kind of simultaneous with the fact that we used to have laws in Maryland that people that were convicted of felonies couldn't vote. But as we know, some years ago, we changed that. And even when I became a lawyer, and until recent years, we used to advise that all jurors were selected from the voter rolls. But since that time, that's changed, and now all jurors come from voter and motor rolls of every jurisdiction. And so the fact that the disenfranchisement of jurors because they had felony convictions was tied to the fact that back then we said you can't vote if you have a felony, but now we allow it. This is just, to me, another step in the right direction of saying that you're restored to your full citizenship once you've served your sentence. We allow people that have finished serving their sentence in incarceration to vote. It seems to me only fair that they would be allowed to serve on a jury, and I want to make it clear that, you know, first of all, one of the things I think is critically important is the fact that there's a juror selection process in every trial where there's a jury. And attorneys get to, through a selection process called voir dire, make challenges. The goal for jurors is, can you be fair? Okay, whatever your background, whatever your situation, the real issue is, can you look at the facts and evidence without bias? And if that's determined by the attorneys that are conducting voir dire, then they should be able to serve. Now, if they can't, then it's up to those attorneys to say, hey, I don't want you on my jury, and use a peremptory challenge and get rid of it. While this is important for criminal cases, because I think it actually opens it up for a more robust jury selection, jury pool, it also opens it up to have people that are more like them to be tried by a jury of their peers. But it also, I want to make it clear, it doesn't only pertain to criminal cases. It pertains to civil as well. And so there's absolutely no reason why a person who, just because they had a criminal conviction, potentially, or a felony conviction, can't make a decision in an accident case or some other type of civil matter. So it's a common sense measure. I really am shocked at, you know, this kind of extreme reaction to it. It's a simple thing. If you can vote, you ought to be able to serve on a jury. And if you're not fit to serve on the jury, the attorneys that make that selection will not allow you to be there. Simple. So for those reasons, I'd move favorable on the bill. I'll accept the chairman's amendment, even though technically that does change the whole the parity between if you can vote, you can serve. It's a little hurdle. I can live with it, though. So
I was going to say I have an amendment to the amendment. But
Okay.
we'll speak to that in a second. But go ahead, Senator. Well, unless if I make a change, what is your comment regarding Senator West, the general bill or the amendment?
I'm not sure that your change will affect my comment, but go ahead and make your change.
So, and counsel help me with this. So basically what I would do is strike felony and restore basically the provisions of the law, the current law. So on line 9 of page 2, you would just strike a felony. And then same thing on line 11. And then restore the language that was struck by the amendment. So it would read...
Oh,
Go
so
ahead.
the Senator Smith's proposed amendment, there would be, so lines 10 through 13,
And you still
it
keep-
would just remain current law. There would be no changes at all for 5 and 10. So the brackets would be removed. The added language in Senator Smith's amendment would go away. So subsection or paragraph 5 would read, has a charge pending in federal or state court of record for a crime punishable by imprisonment exceeding 1 year. The end. Lines 7 through 9, it would read, has been convicted in a federal or state court of a crime punishable by imprisonment exceeding 1 year and received a sentence of imprisonment more than 1 year and is currently serving the sentence imposed for the conviction, including any term of probation. So it would simply strike the felony language in line 9.
That line 9, that's new. That's all new language. And is currently serving the sentence imposed for the conviction, including any term of probation.
Let me then ask my question in light of the proposed new language, which I wasn't able to write down because it went pretty quickly. And maybe Heather can tell us how the new language would affect my comment. So here's my hypothetical. Someone has been convicted of a misdemeanor and is serving time in jail for the misdemeanor. A person convicted of a misdemeanor can still vote. Only a felony conviction disqualifies you from voting. So a person in jail who is incarcerated for a misdemeanor can vote. So here's my question. If we pass this bill with the proposed amendment, could someone who is in jail serving time for a misdemeanor be called as a member of a jury and arrive to sit on the jury in handcuffs and be impaneled as a member of a jury, although the person is in handcuffs?
I love that hype. Only in
So-
JPR do you get that hypothetical.
So under current law, it doesn't deal with whether it's a felony or a misdemeanor. It simply states has been convicted in federal or state court of a crime punishable by imprisonment exceeding 1 year and received a sentence for imprisonment for more than 1 year. So under current law, if you were to take this just at face value with no additional information, yeah, sure, you get it. Say you have a DUI and it's a misdemeanor and you get 30 days and you're called for jury service during those 30 days. There's nothing in current law under that specific provision that would prohibit it. I'm sure that there are other things under current law or procedure that would address the issue that you're raising about a misdemeanor issue of someone less than 1 year who's currently serving time, but that's not covered under current law under this section.
So both under current law and under the new language suggested by the chair, the person who's in jail for a misdemeanor would or would not be able to serve on a jury?
So it wouldn't matter if it's a misdemeanor or if it's not a misdemeanor. It would need to be an individual who is punishable by imprisonment exceeding 1 year and received a term of imprisonment more than 1 year, and they're currently serving the sentence. So it's not about misdemeanors and felonies under the proposed amendment.
Okay, let me come back. My question remains, if someone is in jail, under the current law and under the proposed new language, could that person be called for jury duty and arrive in the courtroom in handcuffs and be impaneled as a member of a jury while wearing handcuffs?
This section does not address it. I'm not saying that there are not other sections or procedures that address it. This specific section does not deal with that scenario.
Okay.
You can't be called to jury duty when you're incarcerated.
I'm just saying under this section, they don't address that issue.
I know, it just seems like a general.
Because you're technically not available. I mean, again, I think that it could potentially come up that you're called under current law and you're locked up and you're not available, so you can't go.
Yes, yep, sure. So, yeah, I think that might need to get fixed, because to the extent that both current law and this bill is silent as to whether you can be called to jury service when you're incarcerated, we may need to clarify that. I originally asked to speak just on behalf of the chair's amendment, because I think in Senator Castley's original concern, his concern that people with pending charges, I think your concern, Senator Castley, is that people with pending charges would have bias towards the defendant because they're in similar circumstances. They both have been charged with the crime. My concern, and the reason I support the chair's amendment, is actually from the other side. I think the bias would be against the defendant, and that a person with pending charges would be more likely to be favorable towards the state's attorney for the purpose of currying favor with the state's attorney in their own matter. And so as someone who wants to be defendant-friendly in these circumstances, I just wanted to put that out there, in support of the chairman's amendment.
Kathleen and everyone else that's spoken about it. I just don't think it's for us to determine bias or non-bias. I think that is absolutely to be determined in the process called voir dire. People have all kinds of backgrounds and circumstances. People have been victims of crime. They've been perpetrators of crime that haven't gotten caught. They can have conflicts of interest because they know people. There's all myriad of reasons why people can't be fair, and that's for the court and the attorneys to make a decision, or even some people may actually go to trial without being represented by counsel. That's for the litigants to determine. So I don't think that's for us to make the determination. All of that being said, I could live with taking out the pending charge because I understand that you have something pending. Frankly, you may not even be able to focus on anything. But again, that's not my decision to make. I think that's up to the court. But I could live with that, just so you know. I don't agree that we need to do anything about speaking about whether someone's incarcerated, because it has never been a problem. It's absolutely never, ever been an issue that's ever come up in any case. So there's no reason to anticipate it would suddenly become a problem.
Yeah, I don't know. We teased out another problem, maybe. I don't know. I've never heard of that either, but I guess we can do some more research and figure out if we can fix it later or something.
I would recommend not addressing it unless
Yeah.
it's been raised as an issue.
Yeah.
I don't want to fiddle with something that's
No, exactly right. I agree. So Senator Cassidy, then Senator West.
2 points. On the voir dire, I believe the defendant gets twice as many jury strikes as the state. I believe that's the case. And what happens is, if you now push people who are have criminal backgrounds into the jury pool, obviously the prosecutor is going to have to exercise some of their preemptory strikes, which means they have fewer strikes. So the defense bar certainly would like the prosecutors to be wasting their preemptory strikes on going after people who are currently in jail and serving time. I think to equate serving on a jury with voting is really disingenuous, because voting is about choosing the person who you want to further your political interest. Serving on a jury has nothing in common with voting, other than that they are pulled off the rolls. Serving on a jury is people who have demonstrated that they do abide by the laws of this state, who are then judging people who are alleged to not have the willingness to abide by the laws of the state. And it's a right. Serving on the jury pool is an important right, and it's a duty. I'm sorry, it's not a right, it's a duty. It's an important duty that we all have. Voting is a right. Serving on jury is a duty that we all have as law-abiding citizens to make sure that the laws of the state are upheld. And we shouldn't conflate the two in any fashion. Thank you.
Oh, thank you. This is very brief. So even if we agreed that somehow serving on a jury is not related to voting, the reality of Maryland's law is that it has been related, because the very reason that people were unable to serve on juries is because they came from the voter rolls, and so they were ineligible to vote. And so various counties initially would not have people that were ineligible serve, and then eventually Maryland codified this, that if you had these felony convictions, you couldn't do it, you couldn't serve. But we've always conflated it. If we shouldn't do it, that's something that we've done historically. So now, this is not the time to separate it. The bottom line is that we want people to fully participate. We do. You have a sentence, you serve it, it's over. It's not supposed to be a way to bar someone from full citizenship for life. It isn't. And to be honest with you, most people are reluctant to serve on juries, and this broadens the pool, the number of people that can be called, so that some of us, like me, that get called about 3 or 4 times, it seems like in a year, maybe I'll get called, my number will come up less. And I think that is actually a service to people as well. I don't really think this should be so controversial. We're certainly far from the only state that will be doing it. I don't remember the number, Senator Castley, but I'm happy to find it. I know I testified about it at my hearing. But anyway, it's really not that. I think you're making a mountain out of a molehill. And I'll also be clear that if a juror is biased, that's a cause. That's a cause strike. So anyone can be, there's no limit to being struck for cause on either side. So that shouldn't be an issue. Thank you.
Wait, but if we have said that they're eligible, then it's not a cause strike. We've said they're eligible. So you can't use a cause strike for that unless the juror said, well, you know, I did time and I think the courts are all crooked and no one would ever get. I mean, come on, that's not a cause strike, Senator.
I just want to volunteer. I think my problem could be solved by adding the following 5 words at the end of subpart 4. Just add the words, and is not currently incarcerated.
Yeah, well, let's do this. Can we adopt my revised amendment? Can we do that?
Yep.
All right, everyone's good. Okay, great. So, counsel, go ahead. Do you have something to say about that?
So I believe that might be already covered on page 2, lines 9, and is not currently serving the sentence imposed for the conviction. Serving would mean incarcerated.
I don't see that language. Is that
Looking
part of the
at
amendment.
Senator
that's part of
Smith's
the
amendment.
Can you read read me section 4 under the amendment?
Sure. So under the amendment that was just adopted, it would paragraph 4 would read, has been convicted in a federal or state court of record of a crime punishable by imprisonment exceeding 1 year and received a sentence of imprisonment for more than 1 year and is currently serving the sentence imposed for the conviction, including any term of probation.
So that wouldn't be covered because if you got a sentence that was for 90 days, you could be in jail. Bring you from jail.
It sounds like it is covered. It sounds like that solves my problem.
Currently serving. So if you want, so
Right.
it sounds like Senator West's amendment that he's proposing would strike the year limitation language.
No, his relates to anybody in jail. And if let's say I'm just serving time for, I don't know what, but it's a 90
Oh, I see
day.
what you're saying.
And then I could be in jail for 90 days and they say, now bring me out of jail to go to
I get what you're saying.
So
I'm
you
not as
would-
hung up on it because it's a misdemeanor. So I'm probably in jail for, I don't know,
Something stupid.
one of the driving offenses where for the 5th time I drove without any tags on my car or something like that. So I'm not as worried about that. But it doesn't really address his problem. It may be a good time to fix that, to say, we don't have to bring you from the detention center to the courthouse to do jury service.
So to do that, I would recommend unadopting the amendment. So leave 4 current law, 5 current law, then add in a 6 saying has been convicted in a federal or state court of record of a crime and is currently serving the sentence imposed for the conviction.
Fine.
Did you say what was otherwise serving? Otherwise, did you say something like that?
Yeah, if you want to skip the serving to keep it incarcerated, so has been convicted in federal or state court of record of a crime and is currently incarcerated or serving the sentence imposed for the conviction.
That makes sense. It's the same. Yeah, she's right, I think.
I think I like that.
That one? Okay.
What's up, Senator Carter? What do you think?
That's fine. I don't think it's necessary. I just want to say for the record, I think I've been practicing law in court since about 1994. Well, I was a law clerk in 1994, and then I was a public defender in 1995. And even though I'm not in court quite as much as I used to be, there was a good chunk of years that I was in court literally every day, mainly criminal and during jury trials and watching jury trials. And absolutely never, not one single time in the history of ever witnessing anything in court has there ever been an issue of someone bringing someone that's incarcerated that's called for jury service. That's just never, ever been a thing. So, that being said, have your will.
Whatever. Can you read it again, just so the committee understands?
So the proposed amendment would put paragraph 4 and paragraph 5 back to current language. And then it would add a 6 saying, has been convicted in a federal or state court of record of a crime and is currently serving the sentence imposed or is otherwise incarcerated.
So wait, are you still keeping this?
I thought you didn't want that in there.
No, I thought I wanted to keep everything the same and just add or is otherwise incarcerated.
Well, 6 would cover that.
Okay. We cover this.
Yeah, has been convicted. Yeah, so 6 would cover that.
Okay. Is everyone okay with that? All right, great. All right. So now the bill's before you as amended. Further discussion? All right, is there a motion? Senator Carter, is there a motion?
I'll make the motion.
All right.
Mr. Chairman.
All right, the motion's for favorable. It's been seconded. We're going to do a roll call, I assume. So, go ahead.
Vice Chair Waldstreicher.
Yes, and just in explaining my vote, we got lost in the weeds here. I'm glad we did because we put out better policy. But according to the Prison Policy Initiative, fully 1/3 of African American males will serve time in jail during their lifetime. That disqualifies a lot of them from serving on juries. That is unacceptable. And we need our jury pools to reflect our populations. And so I'm proud that the sponsor put this in this bill. Thank you, Senator Carter. I'm proud to vote for it.
Senator Lee.
Yes.
Senator Castley.
Pass.
Senator Heddleman.
Yes.
Wait a second, does the amendment take out felons or not?
So the amendment will put 4 and 5 back into current law. So felony references are struck. It would refer to current law, which is exceeding 1 year and received a sentence of imprisonment for more than 1 year. Okay.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter. Pass. Okay. The current law is what?
Sorry. So current law is under 4 and 5, has been convicted in a federal or state court of record of a crime punishable by imprisonment exceeding 1 year and received a sentence of imprisonment for more than 1 year, or has a pending in a federal or state court of record a crime punishable by imprisonment exceeding 1 year. That's current law. And then the proposed amendment would just add or 6, has been convicted in a federal or state court of record of a crime that is and is currently serving, 6, has been convicted in a federal or state court of record of a crime and is currently incarcerated or serving the sentence imposed for the conviction, including any term of probation. So 6 is the new language. 4 and 5 remain current law.
Senator Huff.
Yes.
Senator Castley.
Yes.
Senator Carter.
No.
Chairman Smith.
Yes?
It's your amendment. You better vote for
Yeah.
it.
Yeah.
Bill passed the bill with amendment.
Wait. So, yeah.
To me, like, the amendment is too limiting, and the fact that he...
I didn't change the bill at all.
Except for to add section 6, which we can reread again. But the amendment didn't change anything in the bill. The amendment didn't change anything in the bill except for what.
We need to hold and reprint for tomorrow.
Okay, yeah. Let's. Okay, we're gonna make a motion to reconsider the vote. We'll hold it, reprint it for tomorrow, so everyone has something clean to review.
Yes, but without seeing it...
No, I know I understand. So let's hold it for 1 day, so you get the reprint. Everyone understands. I want to make sure we're all good. Okay, sound good? All right. So now we're on to Senate Bill 776 to Senator Lee, and that's Jamie.
So Senate Bill 776 authorizes a court to admit an out-of-court statement in a juvenile court or criminal court proceeding made by a victim who is a vulnerable adult under certain circumstances, and expands the application of an existing statutory authorization that's applicable currently to children who are the alleged victims in a case concerning certain offenses. The bill also expands application of the authorization to cases concerning child neglect, abuse, or neglect of a vulnerable adult in the first or second degree, or a crime of violence under 5101 of the Public Safety article. There is an amendment in your voting packets. The amendment would expand the application of the bill to not only include just those individuals who are victims in those cases, but also individuals who are witnesses in those cases as well.
It is. State's attorneys wanted it.
Expands it to witnesses as well?
Right. So currently, the law provides that a court may admit into evidence in a juvenile court proceeding or a criminal proceeding an out-of-court statement to prove the truth of the matter asserted. In the statement made by a child victim who is under the age of 13 and is an alleged victim or a child in need of assistance in the case before the court concerning certain offenses. And that those offenses are outlined, if you actually turn to page 2 of the reprint for the amendment that I just mentioned, those offenses are outlined there, and that's child abuse, rape or sex offense, attempted rape in the first or second degree, in a juvenile court proceeding, abuse or neglect, and then what the bill would add is those offenses below. But this would expand it to this amendment would expand it not only to include children who are under 13 and vulnerable adults who are vulnerable adults. Both of which would need to be victims as the bill came in originally drafted, but this would expand it to those individuals who are witnesses.
So I had two amendments. Do you have those prepared? Or
I don't.
Can you speak to them? So
discuss those in concept.
Yeah, let's table this for a second and go to those amendments real quick for a second.
So the idea would be with those amendments to increase to strike the changes that are made to the bill with regard to vulnerable adult, and instead change that to mentally disabled individuals. So vulnerable adults.
Let's just do the age. All right. So first the age, not the vulnerable adult. Let's not touch that yet. Okay. This is the age. So right now, bill comes in. A child is under the age of 13 or vulnerable adult. This amendment would. The proposal would strike the vulnerable adult language and would just raise the age up to under 16. Okay. And then for the vulnerable adult, as Senator Carter brought up last time we voted on this, would include folks that had a physical incapacity but were still otherwise lucid and had full kind of mental capacity and capability. And that's not something that you wanted to go. The vulnerable adult definition is way too broad. And I think Senator Carter's conversation, it was enlightening. It was a very good conversation that teased out, I think, a problem in the bill. So can we just tackle the age piece first, and then, it's tough to kind of redefine or create a new definition of, mental capacity. I don't know if I want to go down that road, but, so let's just stick with that one first. But Senator Carter, go ahead and comment in.
First Amendment, does that raise the age from under 13 to under 16? So it expands the pool of people that could be accusers. So the accuser would now be expanded. So we've already got something in the law, and now we would say that we're going to broaden the pool of people for whom we completely eviscerate the constitutional right to confrontation for the person that is presumptively innocent. So I want to be clear, talking about the criminal trial, and the Constitution says person is presumed innocent, and one of the fundamental rights listed in the Bill of Rights is the right to confront your accuser. We've already carved out an exception for people under 13. Not even sure that I agree with that for many, many reasons, but now we want to expand it to not only people under 16, but this category that we consider to be adults that are mentally incapacitated.
No, so we struck that. It's literally just the age up to.
I just want to add up to 16. Okay,
Correct.
well, I disagree with that, and I would vote no on that amendment and the bill.
Go ahead, Senator Lee.
I believe that the child under 16 still would have to testify. Is that correct? And also the other side could cross-examine that child?
There's two avenues that can happen under. So the current law provides that the statement could be admitted either with or without the child. Under current law, the child victim could either testify or not testify, and the statement could still come in. But because of court cases dealing with the admission of out-of-court testimonial statements, if the statement were to be admitted and the child didn't testify, it would need to be because the child was unavailable, and there would need to be additional evidence supporting the charge.
That the court also has to consider about trustworthiness of that statement that was taken by the child?
So there are factors in the current law that deal with determining the reliability of the statement. So if you look at just working off of the reprint, or working off of the bill, this is on bill page 4. So this would be starting at line 16. So there are a number of factors that are outlined, and that's to determine whether the statement has particularized guarantees of trustworthiness, and the court's required to consider those factors.
Yeah. And I guess the purpose of this was to be able to introduce this statement that was, in the case of a child, that was given to perhaps a physician or a therapist or social worker close to the incident, when the incident happened, because later on, as time goes on, when they finally go to trial, sometimes the child has been under some influence of maybe even the abuser or others, or may forget, or there may be other factors. That was the purpose of this, was it not?
So in, I believe it was State versus Snowden, which was a case in 2005, the court made the observation that the tender years statute was originally enacted. I'll just read right from it. The legislation was enacted in response to concerns that child abuse and sexual offenses were not being prosecuted adequately due to many child victims' inability to testify as a result of their young age or fragile emotional state. And that
The
was,
purpose was to get the statement pretty close to the time the incident occurred, so that later on, when trial did proceed, after much time has passed, at least you could have more reliable evidence of what really happened.
Just basic rules of evidence and hearsay, out-of-court statements used to prove the truth are inherently unreliable. And the reason that we have this thing called the right to confront and cross-examine the witnesses is because the accused has that absolute right to have the accuser appear, make the claim, and the right to cross-examine it. You cannot cross-examine a statement. It can't be done. So it's not able to be effectively challenged. And I understand very much how horrific sex abuse and child sex abuse is. But I absolutely don't think that however horrendously bad it is, it justifies being able to make a case without even having the victim. That's really, really going way too far. Way too far. If we do this, I'm wondering, and maybe I don't even ask the question because maybe they have, but I can't imagine another state has gone so far. And if we do, I think we're going too far. And you know what? If we do it, I bet you we'll be back in here repealing it in another year or two, because we're going to destroy fundamental rights, and that's just completely unacceptable.
Should have the right to confront an accuser, but in this case, we are dealing with a child victim, and sometimes, a child, will feel comfortable with this. Hey, listen to me, everybody. Excuse me. I'm sorry, colleagues. Can you listen to me? Sometimes a child, when they give a statement to like a therapist, social worker, or a doctor, in a environment that is friendly and nurturing, and it occur close to when the incident happened, they can give a more reliable account of what happened. And then later on, Jamie, isn't this correct that the child can also be compelled to testify at the trial too, and that the defendant has the right to cross-examine that individual?
well, so it's
child?
the two avenues that I talked about earlier. If the statement could be admitted either if the child testifies, so the statement would probably come in through the person that they made the statement to.
The statement taker.
Right. But then they could also testify in the case. But there's the second situation where it could come in, but the child didn't testify. But based on Snowden, that would need to happen only if the child was unavailable, and there would need to be additional
or
evidence provided.
Or if the child was deceased.
So that would, I'm including that within unavailability, right?
And that's a good standard, because there's no way somebody can testify if they're unavailable, meaning they're dead or some other reason that they absolutely cannot come.
13 to 16, so under 16. And every, add, I mean, you consider child, so all right, 13 is.
Senator talked about, sometimes a child feels more comfortable with this person or that person. They also could possibly be coerced by this person or that person. It actually could be this person or that person to whom they've given a statement that could actually be the abuser. But why do you need that person, the child, to come to court? So that they can say, I'm sorry, Senator Lee, I didn't mean to say that you lied, that you did this to me. And when they confront the accused, they're unable to continue with something that may not be true. It's critically important that anyone that is accused of a crime has a right to confront that accuser, and only through the most extreme of circumstances where this would not be plausible should we change that. So this is a very terrible bill.
Senator Lee, we want to make sure you can respond, but let's get other people in as well, if that's okay. Senator Huff, I don't think you've spoken on the bills.
I was just going to say, I think the problem is, I'm just not sure on this. I think Senator Carter's making some very good arguments. I want to be very careful before we go forward with something like this. The problem is, this wasn't in the bill as it came in, and so we haven't had a hearing on it. I haven't had the state's attorney, I haven't heard from the Office of Public Defender, hear both sides, before we make a change to due process like this. So I would prefer we not go forward with this amendment, just because it's a different bill. I mean, it's fundamentally a different bill than we had a hearing on, so.
All right, Senator Castley, and then back to Senator Lee.
So, I mean, look, I also think Senator Carter's making a good point on this one. Currently in the bill, we have a presumption that a kid 12 and under will be traumatized and they're of tender years, which probably applies to most kids 12 and under. But I've seen young people 13, 14, 15 who were really had their stuff together, very impressive people. I could see if there was a weighing test where this doesn't involve any kind of a weighing test, though, where a court would say, let me evaluate this 15-year-old and see if they need to testify in this, if we need to admit hearsay. I don't see where that weighing test is in the statute at all. I mean, if you showed me a 14 or 15-year-old who was just mentally traumatized, but we don't make that finding. It's just, it sort of goes automatically. And then the other part of this on I think we have to be careful of is expanding it to witnesses, because the child who's been subject to the trauma personally, there's sort of a inherent, sort of more reliability. This is the person who was attacked or victimized. They were either sexual or a crime of violence. They're traumatized, so we make this exception. But this other person is a witness. They didn't go through that trauma, and there's no finding of the trauma. So as the statute's currently there, we know this child is 12 and under, and they were a victim of one of these terrible offenses. But as we're proposing it, it's a person who isn't necessarily a little child and who didn't go through these terrible offenses. So I share Senator Carter's concerns on both accounts. Thank you.
So I don't think the witness amendment is before us now. I think we're just talking about the age amendment. Senator Lee.
Okay. We're just talking about this amendment dealing with an age change. This is still the current law. We're changing it from under 13 to under 16. Now, this was really not my amendment, but it was a compromise because during our proceedings, there was, I forgot which senator brought it up in this committee, that what about the kids between under 18 and 13? And so this was designed to address that issue. 13 is under 13 is the current law. But also I have a concern about, the reason why we want to take this out-of-court statement is we want to take it close to the time when the incident occurred, because between the time of the incident and the trial, there could be some undue influence or coercion of that child during that time, because they may go back to their household, they may have to live with the abuser, or they just may, over time, just be influenced by other factors. And the court has to consider also, in admitting that statement, 13 factors that are under current law right now. Go ahead, Senator Carter. Yeah.
Thank you. Two quick things. One, I just want to say, well, we anticipate there's no prohibition of giving a statement. The issue is that you have to be able to you have to be there to testify, so that if it is in fact true that your testimony conflicts with the statement, then possibly that could be used to impeach your testimony. That's the statement is fine. The issue is you need to physically testify. But my other question is, under the bill, because we're talking about sex abuse, but could we get a rundown of every single, because I think this expands not just to witnesses, but also to crime. This covers, so will, Chairman Smith, your amendment takes out crimes of violence and witnesses?
My amendment doesn't speak to that.
So this isn't just sex abuse, this is other crimes, correct? Violent crimes including second-degree assault, correct?
That's what hers says.
Okay, well,
So,
it's a no for me.
so we,
Just roll it as is, see what happens.
it's, you go ahead, Senator Heddleman, then you got a motion to roll it, but
I still have a question. I'm a little confused because I went back to look at some of the testimony, and I understand about the admitting the hearsay, but it's a lot of the testimony says that the person actually has to testify in court as well. Is that true? So you do have the opportunity to cross-examine them, right? And do you have the opportunity to cross-examine them about the statement they said outside of court?
Right. It depends. I mean, so if you look at page 2 of the bill, or excuse me, it is page 3 of the bill.
Of the reprint?
Right. I'm looking at the reprint. So bill page 3 of 6.
Uh-huh.
So just starting at line 8, it says, under this section, an out-of-court statement made by a child or a vulnerable adult, victim or witness may come into evidence in a criminal proceeding or in a juvenile court proceeding other than a Senate proceeding to prove the truth of the matter asserted in the statement. One, if the statement is not admissible under other hearsay exception, and 2, if the child or vulnerable adult, victim, or witness testifies. But then if you go down to line 15, provides that in a Senate proceeding, the juvenile court, under Title III, Subtitle 8 of the Courts article, an out-of-court statement made by a child, victim, or witness may come into evidence to prove the truth of the matter asserted in the statement, if the statement is not admissible under any other hearsay exception, and regardless of whether the child, victim, or witness testifies. If the child or victim or witness does not testify, the out-of-court statement will be admissible only if there is corroborative evidence that the alleged offender had the opportunity to commit the alleged abuse or neglect. So that's the 2 avenues that I was talking about, and I apologize for not being clearer earlier. That situation where it's admissible regardless of whether there's testimony would apply only in the Senate proceedings, right?
Right. But again, only if.
You're going to expand this to SINA?
No, that's current law.
Current law allows SINA? I didn't.
Senator Lee, what's your pleasure?
Is that true? Jill, is that
Read
true?
the bill.
She wants to roll it. Roll it as is? Let's take it down. Let's take it down.
Okay. With the amendment, you mean? Or what are we rolling on? How about wait hold on just a minute. I'd like the way it came in with my amendment. That's how I would like it. Just a minute. Hold it. This is wrong. Okay. The one that they handed out. Give me a second, Mr. Chairman. I just want to talk with some of the advocates.
You want to roll? We roll it if you're ready to. I think people are ready to roll. Senator, we're going to get off of this one way or another. So, Senator West, go ahead.
So we've had a little confab over here, and the senators on either side of me, as well as I, wonder about why witnesses were added to the bill. Well, I understand.
No, we haven't. I think.
I
Was that her
understand
amendment?
children. I understand vulnerable adults.
Amendment.
Yeah, we haven't added that yet. That's a sponsor's amendment. She wanted it. You want that in? You want your amendment in?
Added that at the request of the state's attorney.
Then you want to roll it after your amendment?
I think a lot of people don't know. There's a lot of misunderstanding of this bill. I would like to have total clarity before we move this, so everybody knows what they're voting on.
I understand the amendment.
Very overly broad with vulnerable adults, and I understand the amendment which seeks to raise the age from 13 to 16. That's not even, okay. Well, anyway, that's
Do you
horrible.
Mr. Chairman? Mr. Chairman, do you want to just
That's
roll?
horrible.
Hey, okay, sorry, excuse me, I didn't mean to do that. Please excuse me for my disrespectful behavior. Okay, maybe we can roll it about the witness, the amendment, just that, not the bill itself, okay?
You want to roll just the amendment? Or you want to roll the bill without the amendment?
We were asked to put the provision in about the witnesses, okay? And so, can I have the time to respectfully ask the advocates if, I want to do what they want to do too. I want to work together with them. I want to do what's best for the child who's been subject to abuse or neglect and a vulnerable adult. That's what I want to do. I want to do this right. I don't want to do a half. I want to do this right for who we're trying to fight for.
All right, so
No, you can't go home yet.
Let's just. Everyone understands the amendments. Everyone understands the bill. We are where we are. You want to slap that amendment on there. You want to roll it clean, but I think everyone understands what the bill does and what the amendment does. So we can roll it, or you can, hold it. But I mean, I don't, see where the committee is. No, roll the bill or the amendment, but I mean, I think the committee is where it is, so you gotta, this bill, if you hold it, it's not coming back on the list. I mean, you see where everything's going here. Sure. $8:20. I want Senator West to be able to just explain the letter that you got from Ms. Maffaletto. So let's do that, and then we can get out of here. And I do want to revisit a Senate bill. I can do this tonight, but just put on notice Senate Bill 88, which we skipped over. But I'll just make a statement on that when we wrap up.
Okay, we're back on Senate Bill 820, which is the remote execution.
We're not going to have my latest.
Okay, Senator West, thank you for the indulgence here. We're gonna go ahead and go back to the.
Yeah, that's fine.
All right, so go ahead, Counsel Jamie, go ahead and explain what we're voting on, and then we'll roll call.
So this would just be the bill clean. So it would apply to vulnerable adults and would add to the offenses or the cases that the exception would apply to, or that the statute would apply to include neglect of a minor under 3602.1 of the criminal law article, abuse or neglect of a vulnerable adult in the first or second degree under sections 3604 and 3605 of the criminal law article, or a crime of violence as defined under 5101 of the public safety article. So it's just adding vulnerable adults in those cases.
So what's the,
Motion is, I'll make a motion, if there's a lag one. I make a motion unfavorable.
Second.
all right, stuck it in there, all right. So we get a motion, it's unfavorable, so the motion is for the unfavorable, just so everyone understands, and we're going to roll call.
Vice Chair Wildstraker.
Yes.
Senator Lee.
No.
Senator Castley.
Yes.
Senator Hedelman.
No.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
It's gone, so yes, it's over. Yes, it's over, so it's, what is it?
Bill's unfavorable.
Bill's unfavorable. All right. 776, Senator West, right? Sorry, never mind. No. Sorry, 820. My bad. Senate Bill 820. We'll begin with Ms. Mappaletto.
The memo that she sent, and I circulated first thing this morning to everybody. So the key there is that, I'm just going to read the last paragraph on the first page. It's important to note that the signing of these documents is not the first step in the process, but rather the last. This last step is always preceded by one or more communications with the individual as to his or her wishes. Based on those wishes, documents are drafted and reviewed by the individual. As attorneys, we are assessing competency and free will and making sure the documents represent the individual's wishes throughout this process, not simply at the final step when the documents are being signed. As Senator Carter explained about her mother, she made sure that her mother knew what she was doing, even though she disagreed. She needed to know that the documents represented her mother's wishes. This is exactly what we do throughout the process, not just at the point of signing. In fact, in my experience, the signing is very perfunctory. There's not much conversation going on. The documents reflect what has been agreed on earlier. The substantive conversations all occur previously, before the documents are drafted. And it's at those, during those periods of time that the attorney gets an opportunity to interact extensively with the testator about what the testator wants, and can reach determinations about whether the testator is of sound mind, and whether the testator is in some way being influenced unduly by some other member of the family or friend. So the last point is in the House bill passed Judiciary Committee 19-1, and it passed on second reader in the House yesterday. Presumably it'll be on third reader in the House tomorrow. So again, this bill is supported by the real property section, the estates and trust section, the elder law section, the disability rights section of the State Bar Association, the Attorney General, the Maryland Mortgage Bankers and Brokers Association, the Maryland Land Title Association. Everybody is behind this bill. And if we do not pass this bill, we're going to have hundreds of wills that were signed over the course of the past year, many of them by people who are now deceased, which will be successfully attacked as being signed inconsistent with Maryland law once the emergency declaration is rescinded, and heavens knows how much chaos is going to occur around this state in our circuit courts. We simply have to pass this bill or some permutation of it in order to validate all those wills that were executed over the course of the past year.
Yeah, just on a couple points. One, I don't think we have to pass it because there's been a million things done under the emergency order we allowed people to, the governor just unilaterally changed to the executive order. I'm not criticizing, I'm just saying he changed the whole way we vote. So no one's going to go back and undo congressional elections, or no one's going to, the governor allowed everything to happen remotely. So I don't see, it's like if we don't pass a law on all the 1,000 things he allowed to happen remotely because of COVID, it won't undo all of them. And then her point is, well, where the bill, though, doesn't say they have to physically meet together, does it? She's saying, well, we do it all electronically and sign, but we would meet together beforehand. But does the bill stipulate anywhere in the bill that they would actually, the attorney would meet the testator, or any of that stuff would happen in person? Not in person, but electronically. Yeah, so for all you know, I mean, well, I guess that's why I'm sympathetic. That's why I'm worried at the bill, because like I said, we just sat in here 2 years ago and had a slew of bills where the elderly were being taken advantage of, and the new spouse would kidnap the, Casey Kasem, and so who's to say the new spouse isn't the person that's emailing all the stuff, over and all this? I mean, it gives me great concern, because we just went through this a couple years ago, the opposite, worrying about the elderly being taken advantage of, and, people being kidnapped and taken away to other states and their will changed. I mean, we had just a slew of bills we dealt with.
Well, no attorney is going to preside over a signing.
There's not every attorney is
kidnapped
ethical.
And taken to another state.
Not every attorney's ethical. They'll find someone to sign off on this stuff. They found attorneys to sign off on the other terrible stuff they were doing to people under the current law. So my problem is, in her reasoning, none of her reasoning matches what's in the bill. She's saying, oh, we'll meet with them, we'll deal with them. Well, the bill doesn't say that. And I just don't foresee, because we don't change our law. The state of Maryland has had this law for hundreds and hundreds of years, and we've survived. And I don't believe that every action is going to be undone under the executive order. The governor lawfully in the executive order could change. He changed tons of laws, and none of that's going to be undone because of this. But to me, though, this makes permanent what was done in COVID and emergency, and I have discomfort about it.
Well, to answer one of your points, in the second paragraph, full paragraph of her letter, she says, the issues raised by Senators Carter, Huff, and Casserly exist in our practices regardless of whether the documents are being signed in person or remotely, as we've been doing under the governor's executive order. The same level of inquiry that we make when meeting with clients in person exists when we meet with clients remotely. We can engage in a dialogue with the person signing the documents and the witnesses through the audio-visual technology. Most often, the witnesses and notary are not outside people, but they're taken from our own offices and maybe another attorney or member of our support staff. So I'm not sure what is so difficult.
Well, it's difficult because we had cases come in where people were literally, like, their wills were redone when they were senile and out of it. They had new spouses come in, redid their wills, and I think that whole issue will become a lot easier when it's all via email.
Why?
She's saying, because you have no idea. Somebody is completely, they're senile, they're out of it, they're not in control of their faculties, and you have a case where we've had them come in here all the time, where siblings or a family member or a new spouse comes in, gets the will redone, cuts people out, excludes people, and her reasoning is, well, we can talk to them, well, you can, but you don't have to. And in the law right now, we say you have to come in person and sign it. And I think it's important for a safety aspect, given that this part of the law, we've had so many problems testified over this over the years.
Well,
I mean, 2 or 3 years ago was literally like will and estate abuse year, where we had 3 or 4 of these, and we had a slew of people come in.
Well, I don't understand what the difference is between coming in. You say you can always find an attorney to do everything. So you got an attorney who'll do anything, and somebody comes in who's totally senile, and the attorney supervises the signing of a document. Shame on that attorney, and the attorney should be disbarred. And if the attorney does that in person, the attorney can just as easily do it remotely. I don't understand what the difference is.
Because don't you think it's more apt for abuse when you're talking about people who are elderly and maybe lacking faculties, that there is no legal requirement to meet or see the person at all physically, to physically interact with them,
all of the
to even look at them? You don't even know if they're looking at them on a Zoom. It could be a telephone.
All of the substantive work is done prior to the signing.
Yeah, but
the signing is ceremonial.
The substantive work could be by the sibling who wants to undercut somebody else and is doing it all via email on their behalf.
the attorney is required, the attorney in that area, that the practice consists of evaluating the testator to make sure the testator is of sound mind and is not under undue influence. That's how the attorneys practice.
So where is that in the bill?
It's not in the bill, that's the way they practice. Now, if you want to put a requirement in the bill that the attorney satisfy himself or herself that the testator is of sound mind and is not being unduly influenced by someone else, thereby requiring a series of questions and a conversation, I would be happy to add that as another amendment.
I'll defer to Senator Casserly because he had a couple points on this, I think, yesterday.
So this is a little bit unique in that it's pretty common. On a will, it's not signed by the attorney. The attorney makes no representations in the will. Typically, the attorney's name isn't on there. Sometimes it's in an envelope that the will is put into. But what goes in the register, that doesn't go in the register of will. What goes in the register of will for the next 20 years till you die is the will on the people's names who are the witnesses. So the witnesses, they're not perfunctory. They're the only people who, when you're trying to challenge the will, you bring the witnesses in and say, you witnessed this person. That's who you depose to establish that the will's a fraud. Frequently, you won't know who the attorney was, and so many people these days do their wills in online.com. But what this does bring in unique, though, going against what I'm just saying, is it requires a supervising attorney. So this does bring an attorney in to the actual practice of the signing.
And he has to prepare a certification.
They have to prepare a certification, which is unique because now we have these two signatures plus this attorney's certification. Exactly. And he's certifying that that this is a true and accurate copy, and that that the signatures contained are the original signatures of the parties who signed them, and that the testators. I think what still makes me feel a little uncomfortable. I mean, this is great, but the one challenge you have is that nothing requires anyone to actually see the testator in person. They may not be in the attorney's office. So the testator, there's no one who's actually, why doesn't this simply require the witnesses? Why is it so hard to have the witnesses present with the testator? It seems to me that that's an easy solution, unless you're saying, well, we've already executed these things and nobody was present. We're trying to put in place protections for the people who were not, in which case.
That's part of it. As I said in response to Senator Huff, if you all want an amendment to this that requires that the attorney, in addition, certify that he has had an opportunity to have a personal conversation with the testator and has satisfied himself or herself that the testator is of sound mind and is not acting under undue influence, I'll be happy to add that to the certification.
But quite frankly, I think your members of the bar are not going to be happy with such a certification look, I'll go with. I really want something to pass here, so I'm not trying to be jerking around. Right. I remain uncomfortable that who's in the room with that testator, because under this bill, no one who was in the room with that testator will sign, and it's possible that the meeting between the lawyer and the client was done by video, and they asked him a series of questions, and frequently these are, hey, or give this to your, fill out this form, and you help your father, your grandfather, fill out the form, you bring it back, the lawyer prepares the will based upon the form, and now you have the signing, at which point that's when the lawyer sees the client for the first time, particularly for these older folks. So you want to drive them in the office and then say, now you're going to come back again to sign it. It's fill out the form, I know what goes in this will, I'll prepare the will, now you come in, now I see you. But we're going around that. It troubles me that somebody, if this person's old enough that we have to do it remotely like this, it just seems like somebody ought to be with them who can sign as a witness. If we have to have an amendment that says that except for during a pandemic, the witnesses don't have to be there, I guess we could do that to ratify the wills that are already done. But I am uncomfortable that no one would actually be with the person to say, I can see that you're not under undue influence as you're sitting there signing the will. The rest of the bill, I have no problem with the deeds and all that stuff, because the lawyer he's more involved in the process. So that remains my concern. I hear what they're saying, but and I guess if you're having $1 million estate, then you probably did sit down with your lawyers, but most people don't. Most people, you fill out the form, I prepare the will, and now I meet you. That's sort of the standard, and I'm not meeting you, and the witnesses aren't meeting you, and nobody's meeting you, and we're all going to testify based upon a video that what we saw in the video was no influence.
Well, what we
I'm
saw
not trying to
in
be
the-
difficult, honestly. I want something like this to go.
What we saw in the interview was the testator engaging in a conversation. I think from the conversation, you certainly could tell whether the testator is of sound mind. And so
I'm
you're
just saying that
saying, you're
lawyers
saying
don't
if
usually
a,
verify that. That's
if a-
not usually,
if a
I think you have
witness-
trouble with your members of the bar who are going to say, I got to verify this guy's of sound mind. That's,
but you believe that if a witness were present in the room with the testator, that would be sufficient proof that the testator had not been subjected to undue influence by a
influence.
member of the family,
yeah.
just because there's a witness there in the room.
Well, that's pretty, to me, that's what I look for the witness to do. The witness is saying, I sat with this person, I saw no undue influence, I spoke, they showed me their ID, I know who they are.
Okay.
I sat in the room with them.
Well, what if the one witness is the person that's like, the problem person, that's like taking advantage of it?
Yeah, but the law says that you can't be, a witness can't be somebody who's
Who's in the will?
benefits from the will.
Oh, okay.
All right, how about this?
They're their best friend.
Let's do this. So can the two of you get together
Yeah.
and we
Yeah.
can come back
I'll be glad to work
on
with
this
you.
tomorrow?
Let me go back to Ms. Muffaletto, let me talk to Senator Cassidy, and I'll come back tomorrow with an amendment.
All right, that sounds great. That's how the magic's made. All right, so then with that, we've surpassed our time here. The voting list is going to get published here soon for tomorrow. We have House bills again. So that should go fairly quickly. I think we spent a half an hour on hearings today, so we'll just vote right after floor and hearings. So same schedule as tomorrow. All right. Thank you all very much. Have a good night. Happy St. Patrick's Day. Yeah.